Shalom, everybody. It's wonderful to be with you all, and especially with our speaker, Professor Ruth Halperin-Kaddari, who is back on popular demand. The webinar a couple of weeks ago generated so much interest, and there were unanswered questions, and the issues are really core issues. So we are grateful to Ruth for agreeing to come back, and we are delighted to have so many of you returning to hear more answers to questions that were unanswered. In a minute we'll actually start, and I'll present the issues to Ruth and she'll respond. But just one word about the next webinar, because we didn't manage to put anything in writing. So 2 weeks from today, we'll be hosting Professor Tamar Herman of the Israel Democracy Institute. They launched today their annual 2020 Democracy Index, which is a large-scale annual survey of different aspects relating to democracy in Israel. The findings are dramatic, are interesting, are disturbing, and in many ways, the webinar will address a general insight and findings, in addition to a particular focus on issues relating to religion and state. So stay tuned. An announcement will go out in a couple of days, but 2 weeks from today, same time, we'll have the next webinar dealing with a large-scale annual study of public opinion relating to issues of democracy. For instance, one of the most fascinating issues is the question of Israel's identity as a Jewish and democratic state. Is it too Jewish? Is it too democratic? Are they compatible? Who thinks what? So that's just a sense of what's to come. This webinar, as previous webinars, is being held in co-sponsorship by Chidush, Ruach Chidush, Rabbis and Kentes for Religious Freedom and Equality in Israel, J-Plan, the Jewish Pluralism Legal Action Network, and the American Association of Jewish Lawyers and Jurists. We are privileged to have some of the key leadership of these organizations with us on the webinar today, in addition to someone who has a special interest in freedom of marriage in Israel and plays an important role in advancing marriage freedom in Israel. And that's David Lentz of the Metro West Jewish Federation. Now, David, are you already the chair or still the vice chair of IREP, the Israel Religious Expression Platform, which is sort of a benign name for the Jewish Federations of North America effort at advancing marriage freedom on the ground in Israel? So we are grateful to David for joining us, and probably others as well. All right, with that in mind, Ruth, the microphone is yours.
Thank you, Uri, and thank you to everybody who joined us this evening. I'm really honored and pleased, and I find it actually very encouraging and moving that there was so much interest expressed in wanting to delve more deeply into the issues that were raised in the webinar 2 weeks ago. And there was so many questions that were put on the chat, and Uri was kind enough to download them and to put them in order. And then we discussed it together, and we came up with a few subjects, general subjects, and I will try to go through them. And so this is, you could even label it like everything you ever wanted to know about all sorts of marriages in Israel and you never had the chance to ask, or something like that. But I will already say in the beginning that on some issues, I will not even be able to supply the definite answers. One thing that really characterizes family law in Israel, and I keep telling it to my students in the courses I teach family law. I've been teaching it for probably more than 25 years now. But one thing hasn't changed, and that is that so many questions are unanswered. And from a legal point of view, and I'm sure there are quite a few jurists here in the audience, from a legal point of view, that's terrible. You know, there is just no predictability and no certainty in such a sensitive area of law. But it really is a characteristic of the tensions that this area of law in Israel is suffering from. And that's, everybody can easily understand that that is the result of what Uri just mentioned a few minutes ago, right? Israel struggled to be both and at the same time a Jewish state and a democratic state. So this really leads me to the very first question that was posed on the chat, and that was, what about Israel's attitude to international conventions that guarantee freedom of marriage? And it's not just a question of Israel's attitudes, it's the question of Israel's commitment to those conventions, international human rights conventions, which Israel had in fact joined and is a party to. In the early 90s, some of us call it the golden era of Israel's human rights, commitment to human rights, because within 2 years, Israel joined all the main conventions, international human rights conventions, and that is the International Convention on Civil and Political Rights, the International Convention on Economic, Social, and Cultural Rights, the Convention Against Racial Discrimination, and the Convention on Elimination of all forms of discrimination against women. And that's a convention which the treaty body that oversees the implementation of that convention, which is called CEDAW. I had the privilege of serving there for 12 years, 3 terms, twice also as vice president of that convention. So these conventions, Israel ratified them in 1991. And then in 1992, Israel adopted what is generally viewed as the constitution, the basic laws, right? Basic law of human
liberty and dignity.
Dignity, sorry, thank you. Human dignity and freedom, and freedom of occupation. So 1991 and 1992 were really the era of human rights in Israel. And going back to those international conventions, such as the civil and political rights and the elimination of discrimination against women, they both contain a very clear and broad commitment and obligation of every country, every state that joins that convention, that ratifies that convention, to guarantee freedom of marriage. Freedom of marriage to every adult without regard to religious affiliation, without regards to origin, and obviously freedom of choice of the way to marry. And it also guarantees equality between the spouses in all stages of the marriage, in entry to marriage, during the marriage, the marital life, and in the ending of the marital relationship. So it's a clear human right guarantee, which Israel supposedly took upon itself when it joined those conventions. And as we saw 2 weeks ago, Israel violates these human rights guarantees or these human rights commitments. So how does it go together? The answer to this is very clear and maybe somewhat disappointing. And the answer is that international law allows for countries to join in such international obligations while keeping some of these obligations, quote unquote, on hold. And that is through a system which is called reservations. This system of reservations means that if a state joins a convention and takes upon itself all the obligations included in that convention, it can include a reservation saying that one, two, or a number of those obligations are obligations that the state is not committing itself into. It's not taking upon itself to actually implement and commit to them. And in both the Convention on Civil and Political Rights and the Convention on Elimination of Discrimination Against Women, Israel indeed entered such reservations to those provisions that guarantee freedom and equality in marriage. With respect to the Convention on Elimination of Discrimination Against Women, Israel also entered a reservation that has to do with guaranteeing gender equality in public life. And the reason for that is also closely tied to issues of religion and state in Israel. The reason for that is that it is thought that women are precluded to serve as religious judges, as dayanim, or as kadi in Sharia courts, right? Let us not forget that only 80% of Israeli citizens and residents are Jews. 20% are non-Jews. Most of those 20%, about 17%, are Muslim Arab, Palestinian Arabs. And there are also those who are Christian. And obviously there are those who are not regarded as Jews in terms of the Jewish Orthodox tradition. They see themselves as Jews. Under the law of return, they are deemed as Jews, but for purposes of marriage and divorce, they are not Jews. Anyway, going back to those reservations, which I mentioned a minute ago, so Israel entered reservations for all those articles that provide and guarantee freedom of marriage and equality in marriage, and also gender equality in public life, as much as it relates to those formal positions in religious institutions. And by entering these reservations, Israel excluded itself from being committed to these international human rights guarantees. So that's the formal answer to this question. And I said it may be disappointing because it means that countries can actually opt out of such international obligations. And we must bear in mind that Israel is the only so-called Western country, or country that belongs to the industrialized world, the global north, that in fact entered such reservations. These articles, especially the one in CEDAW, on the Convention on Elimination of Discrimination Against Women, is the article which is the most reserved article within international human rights conventions. And almost all the countries that entered these reservations are Muslim countries or African countries, all on account of religious laws that preside over these issues of personal status laws, of marriage and divorce, of family laws. So either religious laws or customary laws. And Israel is the only other country from the global north that joined that club. And that really says something about the question of whether Israel can indeed see itself as a Western country. as a country that belongs to the liberal democratic countries, I think it really raises a lot of doubt about this. Okay, so that was the first point. The second subject that was raised was the question of same-sex couples. Now here, it's really fascinating because we come to what may look as an inexplicable paradox. And the paradox is that Israel is in fact one of the most progressive countries in guaranteeing rights to same-sex couples. And by guaranteeing rights, I mean almost practically everything besides the formal marriage, the formal possibility to actually marry in Israel. But bear in mind that same-sex couples are in good company with other couples who cannot marry in Israel on account of religious law, which is the exclusive way to marry in Israel. So same-sex couples are in the same category as a person whose Judaism is doubtful or is not regarded as Jew by the rabbinical court, who wants to marry a Jew, and they're in the same category as simply a Jew and a non-Jew, or as same category as a Kohen and a divorcee, or a mamzer or mamzeret and ordinary Jew, right? All these and others cannot marry in Israel. And likewise, same-sex couples cannot officially marry in Israel. We'll get in a minute to all those ways of bypassing this restriction, okay? But for the time being, I want to say a few more words about the wide recognition that Israel does accord to same-sex couples. So putting the question of official formal marriage aside, all other purposes of the spousal relationship between two men or two women, they are provided in Israel, and they can be regarded as a couple, as spouses, in exactly the same manner as opposite sex, non-married couples. In other words, de facto relations or cohabitation. And by being in that category of de facto relation or cohabitation, they will have the full box of rights, duties, obligations as any other couple, as opposite sex couple. In fact, that will also include everything that relates to having children and being regarded as two parents to the child. So Israel does allow for a registration of two mothers or two fathers to children. And Israel does allow not domestic surrogacy, but it does recognize the possibility of extraterritorial, interstate surrogacy. And it does recognize the adoption out of Israel. And it does allow, as I said before, the second parent adoption. So in other words, when there are two women living together, one bears a child, the other one can be regarded as another mother, as the other mother, through a process of parenthood order, and not even necessary to go through adoption. So all these rights and obligations, as I said before, it might look as a paradox, right? Because we're talking about a system with so many restrictions on the right to marry. And in the last seminar, and most of you know of the very difficult restrictions on the on exiting marriage, right? The whole problem of the aguna and women who are refused their divorces. So this is such a restrictive system with so many violations of rights. And yet we now hear that with respect to same-sex couples, the question of LGBTQI rights, Israel can actually be regarded as one of the most progressive countries. So the thing is that it's not really a paradox, because the way that these couples can be guaranteed all these rights is by following the path that was structured previously in order to bypass all these restrictions that I just mentioned. Okay? Now, I may have said it in a bit of a convoluted manner. I'll try to simplify it. Because the system is so restrictive, and because the exclusive official religious law in Israel makes so many restrictions on people's rights, the civil system, the civil courts, led by the Supreme Court of Israel, or the High Court of Justice, throughout the years had to find ways to maneuver and to make kind of subterfuges to go around all these restrictions. And that is why it developed two main venues to go around the restrictions over marriages and divorces. One venue is to recognize those civil marriages that couples may have conducted out of Israel. The other venue was, still is, to expand all the rights and obligations that the system accords to people who simply live together without marriage. And I will explain more about both these venues in a minute, because they have to do with all the other questions that you posed 2 weeks ago. But how does all this relate to same-sex couples? The answer is very simple. Once these venues have been opened up and gradually have expanded, and then came the recognition of prohibition on discriminating on the basis of sexual orientation, which Israeli legal system recognized. It recognized the prohibition on discrimination on the basis of sexual orientation. So you put these two principles together and you get the result that if marriage, civil marriage out of Israel is recognized in Israel, can be registered in Israel, then if the civil marriage which was conducted out of Israel was between same-sex couples, between two men or two women, but that other country recognized them as valid and married them and gave them an official marriage document, then the Ministry of Interior has to register them in Israel as well. If it refuses to register them, then it is a prohibited discrimination on the basis of sexual orientation. Now, of course, I'm saying it in a very simplified manner, and it wasn't as simple, right? It did take a number of years. It did take an appeal to the High Court of Justice. And I don't remember, maybe Uri, maybe you remember, was it 10 couples of gay couples who appealed the High Court of Justice? It doesn't really matter, but it did take a legal battle. but the remedy was there. And the remedy was to have them registered just like opposite sex couples who married out of Israel. And the same goes to that other venue, that institute of cohabitation or de facto couples. Once opposite sex couples who live together without marriage can be regarded to all purposes such as social security, such as health rights, such as, well, you know, all the dealings with the authorities, and also for the purposes of the relation between them, the financial obligations between them, the questions of marital property between them. Once they are regarded, they are being accorded with rights just like married couples, then this has to apply to same-sex couples as well. Otherwise, again, they are being discriminated against on the basis of sexual orientation, and that is prohibited under Israeli constitutional law. So same-sex couples, they have the exact same rights as opposite-sex couples. And like opposite sex couples who cannot marry in Israel, they too cannot officially marry in Israel, but they can enter those two institutes that replace the formal marriage, which I just explained about. And there's a twist there, just to wrap up and conclude this point. In a way, their situation is even better than opposite sex couples, because, and this is a paradox, they are the only couples in Israel who can in fact have civil divorce in Israel. They can actually they're the only Jewish couples in Israel who can actually divorce in family courts. Now, how come? And this is really a twist to the whole story. The rabbinical the rabbinical jurisdiction law says that a Jewish couple can marry in Israel, can be married and divorce in Israel only under Jewish law and only in rabbinical courts. So a Jewish same-sex couple, theoretically, if they married out of Israel and they are now registered as married in Israel, just like opposite sex couples, and they want to divorce in Israel, theoretically, this section of the rabbinical court jurisdiction law, this section applies to them, and this section sends them to the rabbinical court. So about 10 years ago, a same-sex couple who, unfortunately, like many opposite sex couples, decided that they want to split up, they want to divorce. They were married out of Israel and they registered in Israel as married, and they wanted to conclude their relationship and be officially divorced and change their status from married to divorce. So they go to the rabbinical court and they ask the clerk at the rabbinical court to open a divorce file. And the clerk looks at them and they say, "Who wants to divorce? You too want to divorce? You want to open a file of divorce? I have to check that. Please come back tomorrow." And they came back the following day. And again, they were told to come back tomorrow. That went on for about 5 days. And then their lawyer, who actually consulted with me and with some other experts, decided to adopt a thesis that I really have the rights to that thesis. It's called the non-recognition thesis. And this theory is really very simple and very logical. It says, and I wrote it in an article about 15 years ago in an academic paper, and I said very simply that if the rabbinical court does not recognize something, it does not recognize a legal construct, that legal construct from the perspective of the rabbinical court simply doesn't exist, then it cannot have a jurisdiction over something that it doesn't recognize. That's the only logical conclusion, right? That makes such sense. And since the rabbinical court does not recognize the possibility of marriage between people of the same sex, between two men or two women, that marriage does not exist at all in the eyes of the rabbinical court. So it cannot have a jurisdiction over that couple. And their lawyer knew that theory, read the article, and I explained the theory to her. And so the following week, they opened a file with the family court. And the family court indeed accepted this non-recognition theory. And from that precedent, from that case, all same-sex couples in Israel can actually have civil divorces, and no other Jewish couples in Israel can have civil divorces. So that's really, I think, such a maybe even absurd outcome, but that's the situation. Okay, so the third point was, we can go over that very fast, the question of children. And here too, I know it is a bit difficult to grasp because it's counterintuitive and it goes against the whole tradition of the common law. But rights of children and the status of children, the standing of children is not affected at all by the relationship between their parents. In other words, the concept of an illegitimate child never existed in Jewish law or in Israeli law. And it mustn't be confused with the concept of a mamzer, or the way it's translated, a bastard, right? A mamzer is a child born to illicit relations. Most common of these categories of illicit relations is the category of a married woman who has relations with another man who is not her husband. And if a child is born to these illicit relations, then the child is mamzer. And he or she will be precluded from marrying a Jew in Israel under Jewish law. But none of their rights or obligations, nothing in their relationship vis-a-vis their mother or their father is affected. Okay, so whether the parents were married to each other, whether the parents were married to other people, whether they married or not married, it doesn't matter. The relationship, the parental-children relationship, are not affected to any extent by the question of the relationship between the parents themselves. So I think that we can put the question of children aside. And now I want to get to the fascinating development in Israel, which has really expanded in the last decade, and that is the phenomena of marriages conducted out of the scope of the rabbinate. I call it non-state marriages.
Second, Ruth.
Yeah.
If it was for a second, your concept, your creative concept of non-recognition generated a number of questions, and maybe while the thing is still fresh in people's mind, you can address it. Namely, so why can't that concept apply to other couples as well, where the rabbinic court doesn't recognize it, whether it's a Reform a Jewish couple that married with a Reform rabbi, or other opposite sex couples that are not recognized, or a Cohen and a divorcee?
Well, the answer is that this concept of recognition or non-recognition has to be understood from the perspective and from the precepts of the Jewish law itself. So we may think and we may say that the rabbinical court does not recognize Reform Jews, and it does not recognize the ceremony conducted by a Reform rabbi. But from the legalistic, positivistic perspective of the Jewish law, their relationship may have implications and may lead to a valid or a doubtful, but still possibly valid marital relationship, right? Even if just to some extent, even living together without marriage could theoretically be recognized as forming a valid marital tie under Jewish law. So any Jewish opposite sex couple, even though the ceremony itself would not ab initio be regarded as legitimate in the eyes of the rabbinical court, retroactively, when we analyze it retroactively, it could still lead to a valid relationship from the perspective of the rabbinical law. It's not the same non-recognition as same-sex couples. The non-recognition of same-sex couples is exactly the same as the non-recognition of intermarriage, of interfaith relations, right? From the perspective of Jewish law, there is absolutely never, ever a possibility of kiddushin between a Jew and a non-Jew. And likewise, there is never absolutely whatsoever the possibility of a kiddushin between a man and a man, or a woman and a woman. And that's unlike relationship between Jewish men and Jewish women. These relationships could always theoretically lead to a valid or doubtful, but still possible, theoretically possible relationship, valid relationship from the Jewish law perspective. So it's not the same. So we cannot really expand this thesis, this theory, to give us the solution for non-Orthodox ceremonies and non-Orthodox weddings. Yeah.
Or a Cohen and a divorcee, for that
matter. Or a Cohen and divorcee, exactly. Mm-hmm.
Go ahead. You were starting to speak about the Orthodox who marry outside the rabbinate.
Yes. Okay. So let's just remember for a moment what I already mentioned. Those two venues that, or could even call them institutes, that were developed by the civil system, the Supreme Court, High Court of Justice, over the decades, to go around these restrictions and offer solutions for people who cannot. Uri, can you mute?
Yes, I'm doing that. Okay, just unmute yourself if you are muted.
Now I unmute myself. Okay, so the Supreme Court actually built these two solutions institutes to overcome the restrictions and the prohibitions and to offer solutions for couples who could not marry in Israel. One of them is to go abroad and get married civilly out of Israel and then come back and register your marriages. And the Ministry of Interior is obligated to register these marriages, and that's according to a precedent from the 50s, a very famous holding, which is very relevant. It's now being actually challenged. And I think Uri will want to say a few words about that. We now call it the Utah marriages. So the Utah marriages episode, which is unfolding as we speak, is actually could possibly challenge this holding from the 50s. This holding from the 50s is the most important one that provides for the formal recognition, the formal registration of marriages that are conducted out of Israel. And these marriages, as I explained before, they could be opposite sex couples in Cyprus, and they could be same-sex couples, not in Cyprus, because Cyprus does not offer marriages for same-sex couples, but Canada, any number of states in the United States, France, other countries in Europe, and there are plenty of other venues. So that's one institute. The other institute is the Institute of Yeduim Batzibur, de facto marriages, cohabitation, couples living together without being formally married. Now, in the 60s, there was a phenomena of people who could not marry in Israel. They were mostly Kohanim and divorcees. And in the 60s, this venue of de facto relations, the recognition of people living together without marriage, was not yet as developed as it is today. And the possibility of traveling abroad and getting married in Cyprus was not really a possibility, a viable possibility, because people simply did not have the money, and there were no, easily cheap direct flights to Cyprus and honeymoon packages that are being offered when there is no corona. So these two solutions that I explained that they exist today, they did not exist in the 60s. But the very peculiar nature of Jewish law, which ab initio prohibits the marriage between a Kohen and divorcee, but says that if such marriage has nonetheless taken place, regardless of the prohibition, that couple nevertheless did go and conduct a ceremony with all the elements that are needed to formulate the Jewish marriage, the acquisition, the ring given from the groom to the bride, saying those words that Harei at mekudeshet li, by this ring I acquire you according to the laws of Moses and Israel. So if all these elements had taken place, it doesn't matter that this ceremony was not allowed to happen. If it nevertheless did happen, it will be regarded as a valid ceremony. And this relationship between the Kohen and divorcee will be regarded as valid marriage under Jewish law, meaning that the wife is a married woman. And if she then wants to marry somebody else, she's not allowed to do that. They are married to every purpose. So these couples in the 60s found out, they understood that there is a way to actually have a ceremony privately, not under the auspice of the rabbinate, of the state rabbinate, but by somebody else, maybe a rabbi, or maybe not even a rabbi. You don't really need a rabbi to officiate such a ceremony. You just need the two witnesses, to the eligible witnesses, which must be men, and they actually have to be also religious men, but never mind about that. As long as you have the eligible witnesses and the ceremony was conducted according to all the elements that are needed to be under Jewish law, then they are married. So this was the first phase of the private marriages. And what these people wanted in the 60s was to have them registered as married couples within the Ministry of Interior, to have the stamp, to have the recognition of the state based on the private ceremony that they conducted. And they managed to get that. Again, through appeals to the High Court of Justice, and there were a number of appeals, like a ping pong between the High Court of Justice and the Rabbinical Court. Very interesting stories. Eventually, the High Court of Justice forced the Ministry of Interior to register them as married couples, because the High Court of Justice said these marriages, according to Jewish law, they are valid. They are real marriages. So that was the first phase of private marriages. What happens in the last decade is almost an opposite phenomena. It's a phenomena of Orthodox and non-Orthodox couples, many of whom can marry through the state rabbinate. They are eligible to marry each other. There's nothing wrong with them. They are regarded as Jews, and they are not Kohanim and divorcees. They are eligible to marry officially, formally, through the state rabbinate, but they don't want to do that through the state rabbinate. It's a vote of non-confidence. They are fighting against this enforcement of religious strictures, or they're fighting against the state official rabbinate, which many of them may see as perhaps even corrupt or non-responsive, or simply does not suit their own system of belief. Some of them do not want the fully religious ceremony, and they do not want to have the full valid recognition of their connection. But some of them are Orthodox and they live according to Jewish religious law, but they want to be controlling. They want to be the masters of their own ceremony, and maybe to have the wedding officiated by a woman, maybe a woman rabbi, or maybe a woman teacher. There's a whole huge generation of young Orthodox men and women who went through the midrashot. The girls, the women, went through the midrashot, Ein HaNatziv, Bruria, Lindenbaum, dozens of midrashot, and they want to have their female teachers, their women teachers officiate in their marriages. They cannot do that under the state official rabbinate. So there are plenty of cases and different motivations of these couples who are conducting their marriages out of the state official rabbinate. And IREP was mentioned before by Uri. The entry of the Northern American Jewish federations into this minefield of marriage pluralism in Israel really gave a boost to mobilizing organically from, as we say, from the ground, מהשטח. There was this need, and one of the biggest organization that now offers this service is called Chupot, but it's really not the only one. The reform movement was there, the conservative movement was there. Other organizations are also offering, providing these services of conducting such marriages outside the state rabbinate. But I want to, well, I'm conscious of the time, but I do want to show you one slide. Uri, can you provide me with the possibility of sharing a screen?
Oh.
For some reason, I cannot share screen. I just want to show you a scheme of, okay, now I can. So here it is. Right, okay. So here you see all the possibilities, because there are numerous questions of what are exactly the outcomes of these private marriages which are conducted outside the state official rabbinate. And the question is, have they, once they conducted their marriage, did they conduct a ceremony that included all the religious requisites, including the acquisition, including the kinyan? If they did conduct that, then under Jewish law, they are in fact married, right? If they did not conduct that, maybe they only had a chuppah, but those words, the sentence of I hereby acquire you by this ring according to the laws of Moses and Israel, this sentence was not pronounced, so the acquisition did not take place. So under pure Jewish law, they are not married, okay? But then there's another twist. The twist is whether they went out of Israel and conducted civil marriage and then had the civil marriage registered in Israel, or they did not conduct civil marriage, and so they are not registered as married. If they are not registered as married, what then is their status? Their status is the same as all those de facto unions, all those cohabiting couples, which, as I explained before, they in fact have the full package of rights and obligations, both internally and vis-a-vis the state, all the state services, except for the fact that they are not registered as married. So, of course, I cannot continue explaining, going into all these details of the various possibilities, but I just, I wanted to show you this, this outline just to explain how complex these situations are. And one of the things that we did at the Rackman Center is that I conducted this research, this analysis, this legal analysis of all these various possibilities. And we had a position paper that explains both to couples who are considering opting out of the state rabbinate and conducting their ceremony privately, and also another analysis, another position paper publication for those service providers, in order for them to actually understand what are the legal ramifications and implications of these services that they provide to couples. And these days I'm conducting a more theoretical research on this phenomena, both from a sociological perspective and also comparative legal perspective. So again, I cannot give you the bottom lines. Some of the reason is also not because it's so complex, but also because we don't know what the bottom lines are going to be like. right? We don't know what's going to happen with a couple who did conduct a full religious ceremony, but did not register, did not have a civil marriage, so they are not registered as married in Israel. What happens if they split up? What happens if they separate? Can they then marry in Israel? Of course, from a religious perspective, from the Jewish law perspective, they must have divorce. How can they have that divorce? Can they apply to the rabbinical court, to the state rabbinical court to get a divorce? Will the state rabbinical court be willing to deal with them? We don't know that, right? Can they have a private divorce? Can they have a private panel of rabbinic court? There already are a number of Orthodox rabbis in Israel who support this mobilization, this enterprise, these projects, and they already declared that they will be willing to conduct such private divorces if there is a need. But what happens if things get, excuse me, the expression, screwed up in a manner that the man does not want to cooperate with such a divorce? What then can the woman do? Can she apply to the rabbinical court in Israel, which has the power, the state power, to force a man, to put him in jail under extreme circumstances? Will the rabbinical court be willing to entertain her appeal in such a case? We don't know. We really don't know. And there are risks involved in these enterprises. That is why we all recommend that such couples who conduct such private ceremonies, they must make sure to also enter prenuptial agreements that contain all ways to overcome such difficult situations of recalcitrant husbands. I think, Uri, maybe I'll stop here and see if there...
We all thought that a follow-up session will answer all the questions that were left unanswered. But I think we realized that not only have we not answered all of them, but we generated a whole host of new questions. So I don't know, maybe we'll let you rest for a while, but bring you back, because there really are a number of issues that are serious. We have not touched, for instance, on a relatively recent development. Actually, it wasn't raised because people may not be aware of it, of recalcitrant husbands overseas. An American couple, they don't live in Israel, they never lived in Israel, and they entered into a dispute that resulted with a civil divorce. The wife says she attempted to get a religious get, but her husband wasn't cooperative. Whether that was a true claim or not a true claim, regardless, she can come to Israel and submit a suit against her husband, who is no longer a husband because they divorced civilly. And when he comes to visit his ailing mother, the rabbinic court has the jurisdiction and the authority to restrain him, keep him in Israel for the duration of enabling her to go through the process of a divorce suit in Israel. They are not Israeli citizens, they are not Israeli residents, and the rabbinic courts in Israel see themselves as the saviors of marriage laws conducted according to Jewish law all throughout the world. I may not have done justice. You may actually see from the women's perspective some merit in this international jurisdiction that Israel gave the rabbinic courts and their ability to restrain and prevent the exit of a person who All he came for is to visit his ailing mother or celebrate his son's bar mitzvah. In any case, there is one question that I wanted to share with you that came up because I feel guilty. I mentioned David Lentz, but I didn't mention Evelyn Kenvin, whom I didn't know was on this call. Evelyn, now again, I don't know whether you are still the chair of IREP or you have stepped down, but for many years was the chair of the Israel Religious Expression Platform of the JFNA. And she asks, what about if one of the couples does not have a Jewish mother, but considers him or herself Jewish, like some Russians? Does that create any special status in the eyes of the rabbinic courts? What do they do?
So in the eyes of the rabbinical court, this man or woman whose mother was not Jewish is not Jewish. And so the rabbinical court does not have jurisdiction over them, but in fact, they are precluded from officially marrying in Israel because Israel only allows for religious marriages to take place, and religious marriage in Israel for Jews is according to the Jewish law. And as we mentioned before, Jewish law does not recognize the possibility of intermarriage, of a marriage between a Jew and a non-Jew. So this is the category, this is one of the category of marriage prohibitions in Israel. What they do is, most of them, they travel abroad, probably Cyprus or another European capital. Prague is, or Budapest are very also very common places to have these civil marriages, and have the civil marriage there, and then come back to Israel and be registered as married. If things do not work out for them and they want to divorce, then they also are not under the jurisdiction of rabbinical court. They have the possibility of civil divorces in Israel, but that is something that has been there, and it is under the law. There is a special law for that. There is a special law that regulates these divorces of intermarriage or interfaith couples, all those couples who do not belong to any one religious court. You don't need the non-recognition thesis for that, because it is a law from the 60s, simply because there is no religious court that can grab and exercise jurisdiction over such couple that belong to two different religions or to no religion at all.
So let's just get to the last 2 points that we said we would address. One is the relevance to the diaspora Jewish community, and especially the American Jewish community. So Evelyn mentioned the Russian Olim, so that's one good example, though once removed, because the American Jewish community and the world Jewish community made it possible for the Russian Olim to actually come to Israel. And they made it possible twice. Once by the Let My People Go effective advocacy, actually in spite of Israeli governmental objections, and then financial support for the Operation Exodus and the resettling, etc., etc. According to the official numbers, out of the 1 million or so Russian Olim, former Soviet Union Olim, there are approximately 400,000 who are in that category that Evelyn Kenvin related to, namely a non-Jewish mother. They are all Israeli citizens under the law of return. None of them can marry in Israel. But the truth of the matter is that it relates to American Jewry directly. Whether it is because Rabbi Lookstein, in addition to converting the most famous female convert in the world today, he converted others. And one of his female converts made Aliyah and realized that when she went to get married, the rabbinic court in Jerusalem and then the rabbinic court of appeal said, we don't recognize this Luxtin. We don't recognize his conversions. So modern Orthodox converts and of course conservative and reform and reconstructionist and renewal converts that are recognized under Israel's civil law are not recognized by the rabbinate, and since the rabbinate has the monopoly of a marriage in Israel, they're unable to marry. So whether it is children of mixed marriages, and we all know the rate of mixed marriages, which does not preclude the family from being an active player in the Jewish community. So whether it's children of mixed marriages, in which in most instances the non-Jewish partner is the mother, or converts or children of female converts, there is a direct bearing on the American Jewish community in terms of if it's not you, it's your partner's daughter or partner's son or granddaughter or your family member, your own grandchildren. This is a global issue, and I think Ruth alluded to it a number of times, and therefore addressing the need for freedom of marriage, which IREP recognized and is something that we are focusing on in Chidush and elsewhere, is so critical. And how does one make a difference? For instance, there is now the Utah question, Utah weddings, which is a fascinating, and as Ruth said, it's developing, these very days. Yesterday, there was a petition submitted to the Supreme Court by a number of couples that married via Utah. Now, Utah, you may or may not know, has legally adopted the option of an online marriage where the couple can be remote, overseas, and the marriage officiant has to be in Utah. There are all the legal requirements for a regular registration for a marriage license in Utah, like in other states. And it solved the problem of many, including a growing number now of Israeli couples, except, and this is something that Ruth spoke about, and I think clearly stated it, but it cannot be over-exaggerated. All these solutions did not happen by themselves. Nothing was simple. Nothing was just because of the goodwill of Israel's politician. It happened on two accounts. One is the perseverance, the legal capacity of organizations such as the Rackman Center and such as the work that we do to bring these cases to court, and the court, more often than not, will stand on the side of safeguarding core civil liberties and basic rights of couplehood, and interpret the laws in such a way that would be in line with it. And another issue, Ruth, we didn't discuss is this creative notion of nisu'ei b'nei Noach. Noachide laws, marriages, but that again is something for another opportunity. Very creative. That shows that the rabbinic courts can actually be creative when they have an interest to be creative. But back to the Utah. So a number of couples were already married and registered in the Israeli population registry based on the notion of whatever private international law and mutual recognition. And Ruth alluded to the 1962 precedent that, again, against the objections of the Ministry of the Interior, the Supreme Court ordered them to register an overseas civil marriage, saying, this is a complex legal issue. The clerk has no special knowledge. It's controversial. Don't bother. You get a legal marriage certificate. You see that it's an authentic civil marriage certificate that was obtained according to the laws of the country, normal country, democratic country, law-abiding country that issued that license. Register it. Don't bother about the intrinsic validity because there are many controversies over that. Register it. And once it's registered, as I think Ruth alluded to as well, for all practical intents and purposes, that marriage is perceived by the authorities as valid. So a number of couples went through that process, were registered. Fortunately, it's an inexpensive process. It's an accessible process. It's a quick process. And then Rabbi Aryeh Deri, the leader of Shas, the minister of the Interior, woke up when headlines spoke about this. And he was lashed by the ultra-Orthodox media. How could you allow that to happen under your watch? And he suspended overnight the continued registration of those legal marriages under the laws of Utah, and ordered the population registry to withhold it until they have a chance to look into it indefinitely. Yesterday, a petition was submitted. Stay tuned, because we at Chidush are looking at collaborating with the American Association of Jewish Lawyers and Jurists and with the local community and the Reform congregation in Utah to do two things: to both actually offer those services without the commercial consideration, without the profit making, so as to make it even further accessible. And the second thing is we intend to put together a statement that will be sent to the policymakers in Israel and possibly a petition drive. And we would turn to you to speak up, to express your opinion, share it with others, make it known. This is about the right to family. This is about the right to marry. And this is about Israel's ultra-Orthodox minister disregarding the law, disregarding 60 years of Supreme Court precedents, and suspending recognition of those marriages, which those couples really have no recourse because they wouldn't be able to marry in Israel. So stay tuned. We'll write to all of you. Ruth, it's been a wonderful experience to be with you again. We sent out the link to one of your publications and your PowerPoint presentation from last time. We'll do that again. If there is any other document that you want to share with those who registered for this session, let's do so. Again, a reminder, 2 weeks exactly, we'll be hosting Professor Tamar Herman, who heads the research, the Viterbi New Policy Center at the Israel Democracy Institute, who will share with us the dramatic findings of the 2020 Democracy Index, which was just released today. And maybe we'll look at the questions afterwards, and Ruth, if we see any specific question that you want to respond to in writing, we'll do that. Thank you, everybody. Any last word that you want to offer, Ruth?
Just about these Utah marriages, we are also considering the possibility, perhaps together, joining with an amicus brief to the High Court of Justice. And yeah, there will be very interesting developments there, I'm sure.
That is fantastic. And obviously, we'll follow up and talk about it. Mm-hmm. Not through Zoom necessarily. We are closer. Good.
Jerusalem.
Shalom, everybody. Thank you, Professor Ruth Halperin-Kaddari, and thank you all for joining us.